accident under paragraph 4 of Article 12 of the Revised Penal Code. Good morning everyone. Welcome to another video here at Recognizance. For today's video, I will discuss about exempting circumstances. And in fact, this exempting circumstances is one of the circumstances that will affect criminal liability as provided also under Article 12 of the Revised Penal Code or Act number 3815 as amended. And now let us distinguish between justifying circumstances and exempting circumstances. When we talk of justifying circumstances, this pertains to the act of the person, while exempting circumstances, this pertains to the actor in the commission of the crime. Now, with regard to the liability of a person committed a crime, in justifying circumstances, the person committed a crime is exempted from criminal and civil liability. On the other hand, on exempting circumstances, the person who committed a crime is exempted from criminal liability, but he is civilly liable. On justifying circumstances, the act was considered non-felonious. Since it is non-felonious, of course, dili siya na to matawag nga civilly and criminally liable except paragraph 4 that talks about the doctrine of state necessity rule. Now, on exempting circumstances, it is considered, the act is considered as a crime, but he is exempted from criminal liability. But he is civilly liable. Now, in exempting circumstances, there are two different kinds of exempting circumstances. First is the so-called general exempting circumstances, and second is the so-called specific exempting circumstances. When we talk of general exempting circumstances, these are those circumstances or those are circumstances that are provided under Article 12 of the Revised Penal Code. Then when we talk of specific exempting circumstances, are those circumstances that also may be found under the Revised Penal Code, like under Article 20, which provides an exemptions to the relatives who committed being an accessory of the crimes for concealing the body of the crimes. So, or also in cases involving slight or less serious physical injuries under exemptional circumstances, as also provided under Article 247 of the RPC, and also in cases involving thief of your relative with your relatives within those relationships provided under Article 332, because they are exempted from criminal liability. Then those articles that I have been mentioned are considered as unspecific exempting circumstances. Now, let us discuss about the general exempting circumstances. These are the following general exempting circumstances as provided under Article 12 of the Revised Penal Code, such as imbecility and or insanity, person under 9 years of age. Paragraph 3 of Article 12 has already been impliedly repealed by Section 6 of RA 9344, accident, irresistible force, uncontrollable fear, and lawful or inspirable cause. Now, with these general exempting circumstances, the burden of proof required for a person who invoked that he acted with an exceptional circumstances is the clear and convincing evidence. The same true with the justifying circumstances. It is a clear and convincing evidence. And I already mentioned that when we talk of clear and convincing evidence, it is on the second slot in the hierarchy of burden of proof. It is not more than a proof beyond reasonable doubt, and it is more than on the hierarchy of evidence as to the preponderance of evidence. Meaning it is in between proof beyond reasonable doubt and preponderance of evidence. Now, when a person, the same true with the justifying circumstances, when a person invoke these exempting circumstances, the burden of proof relies on them. It is not on the prosecution, but it will in favor of the defense to show that they acted such exceptional circumstances. So, let us proceed to under paragraph 1 of Article 12 of the RPC. So, paragraph 1 of Article 12 of the Revised Penal Code provides that an imbecile or an insane person, unless the latter has acted during a lucid interval. So let us differentiate between imbecile and an insane person. So when we talk of an imbecile person, they are those persons suffering from mental condition, that their mental condition is analogous to a childishness, and they are advanced in age, but their mental condition is the same as a child having an age between 2 years old to 7 years old. So with that, they are considered as an imbecile person. An imbecile person is exempted in all criminal liability. Why? Because there is a complete absence of intelligence. Meaning, they don't have any idea on the effects or on the outcome of the act they have been committed. Because there is a complete absence of intelligence. Then, when we talk of insane person, an insane person is not or maybe exempted from criminal liability when he acts or when he committed the crime, or at the time of the commission of the offense, he was insane. However, if during such act there is or it shows that he acted during lucid interval, then he cannot invoke, or that person is not exempted from criminal liability. Why? Because the presumption of the law is that a person is acted sane or during his sanity. Meaning, the one who invoked that he was acting insanity during the commission or at the time of the commission of the crime should provide the so-called clear and convincing evidence. Now, what is the effect of an accused who was being imbecile or insane during the commission of the crime? So, they shall be confined to a hospital or asylum for purposes of rehabilitation and treatment. And they cannot be able to be released from confinement without the order from the honorable court, and of course without concurrence from the Director of Health, in order for them to go back or to continue the criminal proceedings. Provided that an insane person is acted, say for example, he was acted during lucid interval, and during the trial is nabuang siya, so of course isuspend siya, kaya nga naman nga isuspend. Of course, na-insane man siya during trial, of course there is a complete absence na sad of intelligence. Therefore, dili na sad siya makahibaw kung unsay iyahang tubagan or unsay iyahang pang istorya during the trial. That is why the trial must be suspended. kung nabuang siya during trial but nag-commit siya og crime is sane siya, acted during lucid interval. Now, there are different behavior or a mental condition that will say, for example, that will affect the acts of a person. Say, for example, in case of schizophrenia is a form of dementia precox which someone will cannot distinguish between right and wrong or between fantasy and reality. So, with that he cannot distinguish between fantasy and reality because he is suffering from schizophrenia, then he is exempted from criminal liability. Why? Because such act is considered, or such behavior is considered as a form of insanity. When there is insanity, of course, there is a complete absence of intelligence and deprivation of his freedom. Why? Because he doesn't even know the result of his act or di unsa na niya paghimo ang iyang mga or ngano nakakommit siya og krimen. It's because wala man siya'y sakto nga panghuna-huna. Now, another thing also, in the case of the so-called kleptomania may be an exempting circumstances or maybe a mitigating circumstances. It depends upon how the person interact during the commission of an offense. See, for example, when A, ni-commit siya og pagkuha og butang nga dili iyaha, but that is iyaha na siyang matawag na ito nga behavioral problem. Nga kanang gitawag na ito nga kleptomania. Nga kung na siya makitaan nga iyang ganahan, iyang kuhaon. However, we should determine whether such mental condition is irresistible impulse. Meaning to si dili niya mapugngan. So, i-examine niya siya sa psychiatric. So, i-determine. So, karon kung makita gyud nga once na siya magustuhan, iyang kuhaon is dili niya mapugngan. Meaning, he is unconscious. His mental condition is irresistible. Meaning, dili niya controllable. Dili niya makontrol nga makuha gid siya. So, pwede na to siyang isulod sa exempting circumstances. It's because of the irresistible impulse of his mind nga dili niya kayang kontrolon. However, on the case of a person who is suffering from deprivation of his freedom, but he is conscious, on his acts, therefore, pwede na to siyang ipasulod sa mitigating circumstances. It depends upon the interaction of the person who committed such offense. So, that is in the case of kleptomania. Next, let us also include the discussion, the so-called somnambulism or the so-called sleepwalking. In a sleepwalking or somnambulism, this act is considered as exempting circumstances or exempting circumstance. Why? Because when you are sleeping and walking or the so-called somnambulism, again, there is a complete absence of your intelligence because you are unconscious. Because ang imuhang ginahuna or ang imuhang control of your mind is natulog ka. Pag inon pa is gidaman ka. But nakakommit ka og crime during that somnambulism. Of course, wala kay complete intelligence. Nga naman you are unconscious. Wala ka kay bawon sa imong gihimo. It's because of that somnambulism nakakommit ka og crime. Then, you are exempted from criminal liability. You are exempted from criminal liability. Kaya ang somnambulism, there is a complete absence of intelligence. So, again, when we talk of paragraph 1 of Article 12, we are talking about the complete absence of intelligence. Kaya nawala man ang imong complete absence of intelligence, of course, you are exempted from criminal liability. Atong balikon, imbecile, ang imuhang panghunahuna is nasa 2 years old to 7 years old. So, meaning to say, nag-edad na ka og 19, pero ang imong hunahuna is napaka sa 2 og city or in between ana. Of course, dili ka ma-held liable. Even though ang imong edad 19 years old na ka, kaya nga naman ang imong hunahuna kay mura raman siyang bata. So meaning, dili kumpleto ang imong intelihente nga para maka-distinguish ka nga ay sakto ni ay sayop ni akong gihimo. Now, sa insanity we are not talking about the chronological age of a person in committing the crime. What we are talking about is the mental sanity of a person. Kung pananglitan, you are insane at the time of the commission of the offense, then you are exempted from criminal liability. Nga naman, there is a complete deprivation of freedom. There is a complete absence of intelligence because you are insane. Since you are insane, of course, di ka makahibaw unsay outcome sa imong gihimo. Kay di ka makaka-distinguish nga right or wrong ba na akong gihimo, it's because of insanity. Okay. Then, alita sa has acted during lucid interval. Meaning, lucid interval, pasabot ana niya is nibalik ang imong saktong pangunahuna sa panahon nga ni commit ka sa krimen. So naay interruption from your sanity to insanity, from insanity to sanity. Therefore, i-determine na siya whether or not ikaw nga nag-commit sa krimen is nimbalik ba ka sa imong sanity. If mapamatud-an nga nimbalik ka sa imong saktong pangunahuna sa pag-commit nimo sa krimen, ma-held liable ka. Now, during trial, ning balik ang imuhang pagkabuang na insane na sad ka. Of course, akong ningon ganiha i-suspend. I-suspend siya. Nga naman, unsa man paghibaw nimo about the outcomes of the proceedings if in the first place you don't know what they are talking because you are insane. Therefore, i-suspend ang trial dayon patambalan ka. So muna siya gingon sa paragraph 1. I think wala ay laing mga importante aning about imbecility and insane person. And of course, there are two kinds of tests. The test of cognition and the test of volition. When you talk of test of cognition, of course, i-examine ang mental condition sa usa ka tawo. I-examine kung makadetermine ba ka or you have or you are conscious or you have the complete intelligence nga makahibaw ka sa imong gihimo or in the commission of the crime. So if that for that reason nakahibaw ka, of course di na ka ma-exempted from criminal liability applying the test of cognition. Second is the test of volition. The test of volition commonly ma-apply nato sa mitigating circumstances kay dili man siya kung nigtanaw na to, for example, ning pass ka sa test of cognition but on the test of volition is na ay partial deprivation of your intelligence. Nga mura kag somewhat nga nakahibaw ka but not totally on the outcome of the crime or the offense you have committed. Therefore, ma-apply na to sa mitigating circumstances and not on the exempting circumstances. So let us proceed to paragraph 2. So paragraph 2 of Article 12 of the RPC, a person under 9 years of age and the exempting circumstance or the basis of this exempting circumstance of minority is based on the complete absence of intelligence. However, this paragraph 2 is already impliedly repealed under Republic Act 9344 or the Juvenile Justice and Welfare Act of 2006, which already provides that 15 and below or infancy to 15 or 1 year old to 15 years old are considered absolute irresponsibility of the crime they have committed. Meaning they are exempted from criminal liability nga within that age kanang nga akong gipang mention. From, for example, 1 year old to 15 years old, of course, dili na ta diha mag-determine whether or not there is a discernment in the commission of the crime. So kung makakommit sila, they are considered exempted from criminal liability. Reason? It's because there is a complete absence of intelligence. Now, paragraph 3 of the revised penal code was already impliedly repealed by Republic Act 9344, specifically Section 6. Section 6 of the Juvenile Justice and Welfare Act of 2006, which provides that a child 15 years of age or under at the time of the commission of the offense shall be exempt from criminal liability. So meaning, 15 years of age or under at the time of the commission of the offense shall be exempt from criminal liability. So it is very clear under this provisions of the law that si minor nag-edad siya 15 or paubos, they are exempted from criminal liability. So, dili na to siya lalison. Nga naman, because mo may gibutang sa provision nga they are exempted from criminal liability. Wa siya gibutang og mga conditions or conditional provisions nga ato siyang applyan whether or not nga ni-commit siya og offense nga naa siya sa saktong pangunahon na or wala sa saktong pangunahon na. As long as 15 years of age and below, so there is a so-called absolute age of irresponsibility. However, such child shall be subjected to an intervention program pursuant to Section 20 of this Act. Then next is a child above 15 years but below 18 years of age shall likewise be exempt from criminal liability and be subjected to an intervention program unless he or she is acted with discernment, in which case such appropriate proceedings in accordance with this Act and the exemption from criminal liability herein established does not include exception from liability which shall be enforced in accordance with the law. Now, on the second paragraph, nag-istorya na siya of 15 years but below 18. So meaning, 15 years and 1 day to 18 years of age. So here, there was already, based on this provisions of the law, there is already the so-called conditional. There is already a condition. So meaning, it is age of conditional responsibility. Why? Naman siya gibutang sa provisions nga giingon nga with or without discernment. So what is discernment? Discernment, it is an act of a minor at the time of the commission of the crime that he can distinguish between right from wrong. So meaning, kung makadistinguish siya from right or wrong, of course, na discernment. But if he cannot distinguish from right or wrong, so meaning, he acted without discernment. Since he acted without discernment man, so of course, he is exempted from criminal liability. Muna siya gibutang sa provisions, ha? Kung na-acted siya without discernment, meaning di siya makadistinguish from right or wrong, exempted siya from criminal liability. But, subject gihapon siya for intervention program. What if, sir? Acted siya with discernment. See, for example, nanglogos ang 16 years of age. Dayon iyang giingnan ang 17 years old. See, for example, nga babae nga, ayaw pagsaba ha. Kaya kung magsaba, gani ka. Patyon ti ka. Ha? With that, nga giingon, nga pagpanghadlok ni 16 years old nga to sa 17 years old, nga iyahang gilogos, na siya gitawag na to nga discernment. Nga naman, nakipaw siya, unsay outcome. Iyahang giingnan, nga patyon niya. So meaning, he can discern. He can distinguish from right or wrong. Therefore, dili siya ma-exempted from criminal liability, but subjected siya for any mitigating circumstance as the case may be, because he is a minor. Di ba? It depends upon the proceedings or the judicial proceedings in court. Now, another example. What if A is a 16 years old child and committed a crime during night time? The purpose nga iyang gi-commit ang crime during night time is in order for him nga i-conceal ang iyang kaugalingon nga dili siya makita during the commission of the crime. Di na-perpetrate niya ang crime, na-consummate niya, napatay niya ang target. Now, makaingon ba ka nga he is exempted from criminal liability because he is a minor? The answer is no. Why? Because the act of committing a crime during night time in order to conceal himself is an act nga nag-signify nga naa siya'y discernment. Nga naman, ihang giplanuhan, nakibaw siya sa epekto nga kung hayag niya buhaton, of course, makitaan siya. Gihimo niya sa panahon sa kagabion aron di siya makita during sa pagcommit sa krimen. Therefore, makadistinguish di siya from right or wrong. Therefore, dili na to isulod sa exempting circumstances. Maybe musulod na sa mitigating circumstances depending on the outcome of the case based on their argument. Okay, I hope you understand. So, under this 9344, see for example, to those child nga 15 years of age and below, acted, wala mo ta nag conditional dire, nga kuan siya subject for a program and they are exempted from criminal liability but they are not exempted from civil liability. Therefore, liable sila sa civil liability. So yun din, sa pagbayad mo may kortang minor, of course, na siya parents nga pwede mapaninglan sa iyahang liabilities. Arita sa second paragraph, 15 and 1 day or 1 day, 15 and 1 day to 18. So nanatay conditional age of responsibility. You should determine whether or not there was a discernment during the commission of the crime. If there is discernment during the commission of the crime, then ayaw i-apply ang exempting circumstance. Then kung walay discernment, of course, apply ang exempting circumstance. And mahibawa na nimo based on the facts. Kung tanaw nimo ay naagi siya kaalam See, for example, akong gingon ganiha, nga nakahibaw siya nga maong i-conceal niya ang iyang kaugalingon, it's because para di siya makita. Of course, there was discernment during the commission of the crime. Therefore, he is not exempted from criminal liability. I hope you understand under paragraph 3. Now, let us proceed to paragraph 4. Paragraph 4, any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Meaning to say, under paragraph 4, it is the so-called as an accident. It is different from negligence. Because accident is considered as an happening outside the sway of our will. Meaning to say, that is not kanang forcible. Di mo makita and it is beyond your control. Why? Because that is an accident. That is an accident. While on negligence, there is a lacking of your foresight or lacking of your skill, lacking on the conditions in order for you to perform your duties and responsibilities in accordance with the law, but you did not exercise it with due care and ordinary diligence. That's why you are liable for your act. Why? Because what is provided under paragraph 4 is only an accident, provided also that such accident must be performed in a lawful act. Lawful act with due care causes an injury by mere accident without fault or intention of causing it. So going back to my discussion on the topics about felony, I mentioned the definition of a felony. Di ba? Mingon tag felony, a felony is committed by deceit or dolo, or by fault or culpa, and ingon din nga there is deceit when the act is naa siya gitawag og deliberate intent. Remember? So nisulod na si intent natay without fault, intention, meaning intentional felonies, makumit ang felony, intent. Then second, and it also felony committed also by fault or culpa. There is culpa when there is, katong gingon ako ninyo nga in Laporsky, there is imprudence, negligence, lack of foresight, and lack of skill. Therefore, kung naa na siya, of course na felony. Now, under paragraph 4, ningon matadali, causes an injury by mere accident without walay fault, walay culpa, wala si in Laporsky, or intention. So of course, walay intent, walay deceit of causing it. Therefore, ang gipasabot diri nga accident is you are exercising a lawful act with due care not to injure another person, but there was an injury. There was an accident na nigawas, but your act is lawful. Therefore, applying paragraph 4, you are exempted from criminal liability. So let us have an example. Example, in the case of People versus Taniedo, where the accused is nagkuan siya, looking for a wild chicken, a wild chicken. So nakakita siya. Upon looking the wild chicken is iyahang gipusil. Iyahang gipusil. He fired a shot and the slug accidentally ricocheted to a tenant. Ang tenant is iyaharasang kaliwat, di namatay. Now, question, is the act of the accused could be considered as an accident as provided under paragraph 4 of Article 12 of the Revised Penal Code? So based on that case of US versus Taniedo, the act was considered as an accident provided under paragraph 4. So atong tagkatagsaon, nangita siya wild chicken. Is that act considered as a lawful act? So yes, it is considered as a lawful act. Wild chicken. With due care, yes, nag-exercise siya og due care. Nag-exercise siya og due care not to cause damage or injury to another. Iyang gisure nga sa iyang backstop or sa iyang paligid or sa iyang mga kilid-kilid is wala siya maigo nga mga civilian or mga cause of damage or injury. Causes an injury. Now, causes an injury by mere accident without. Tungod sa iyang gihimo, nag-exercise siya, lawful, joker, nakakusi siya og accident. Nakakusi siya accident without fault. So let us consider nga nag-exercise siya joker, of course, wala negligence because that is an accident. Diba? I already differentiate or give the distinction between accident and negligence. May accident that is outside the sway of your will. Diba? And of course, that is beyond your control. That is not forcible. Di mo makita. Di ka kibaw nga mo na mahitabo. Without fault, of course, wala negligence. And without intention, Of course, wala ka intention nga ipatyo ng tenant because your intention is to kill the wild chickens of causing it. Therefore, on the case of US versus Taniedo, the accused was exempted from criminal liability. And of course, under paragraph 4, he is also exempted from civil liability. Why? Because your act under paragraph 4 is considered non-felonious. Remember that on paragraph 4 of Article 11, nag-mention ko nga kanang sa state of necessity rule, kuan siya exempted from criminal liability, but dili siya exempted from civil liability. Remember? Even though ang paragraph 4 of Article 11 nabutang siya sa justifying circumstances, nga mayong tag justifying circumstances is matawag nato nga he is exempted both criminally and civilly, di ba? So but paragraph 4 is kuan siya civilly liable siya. Now under Article 12 nasadta ngari sa Article 12, since an act is non-felonious provided that all the requisites are present. Otherwise, dili maka-apply sa exempting circumstances. Under paragraph 4, since your act is non-felonious, you are exempted from criminal and civil liability. Di ba ningon ganiha sad ko sa exempting circumstances nga kung exempting, the act is considered as a crime but he is criminally liable. He is exempted from criminal liability but he is not exempted from civil liability. So I hope you understand between the difference between the two paragraphs under Article 11 and Article 12 of the revised penal code. Another example para masabtan ang accident. Say for example, there is A and B. Naglalis, there is a commotion between A and B. Nag-ilog or nagsinukmagay na, sundang gubot na. Here comes C, naabot. Abot si C, iyang gibadlong, oy hunong mo, kay kung dili, kay dakpunta mo. Or else, na-commotion, maapil pa siya. So, kinahanglan siya firearm, nagpakuan siya, warning shot, bagbag. So, wala mo hunong, but niricochet ang bala ngadto sa bystander. Pagpa-warning shot ni C, napatay ang bystander. Now, pangutana, ma-apply ba nato si paragraph 4? Yes or no? The answer is no. Why? Because the act of C is not considered lawful. Nga naman, lawful ba din ang maghimo siya warning shot? With Joker, nag-exercise ba siya with Joker? No. Nga naman, wala siya nagunahon na nga ang posible sa paghimo sa iyahang warning shot is mo igo sa mga bystander. Nga naman siya sa public na area. Meaning to say, kinahanglan mo exercise kag ordinary or extraordinary diligence na dili ka maka-apektar o maka-cause or injury to another person. So, causes an injury by mere accident. So, let us just say, for example, naka-cause siya injury by mere accident, but, mingunta, without fault, dili with fault siya on that example. Kaya nga naman, kinahanglan, know your backstop, know your surroundings. O sa ka magpa-warning shot. And in fact, ang warning shot is not a lawful act. It is unlawful. It is unlawful. Ang pwede is megaphone. Para mahimo siyang lawful. Para mubadlong ka sa mga any person nga nag-away diha along the street or find another operating procedure to arrest such person. So, or intention of causing it. So, wala siya ni sulod sa intention. Of course, wala siya intention nga mapatay sa bystander. However, masulod ta sa fault. Di ba may tag felony is makumit siya duha by dulo or culpa? Wala ni sulod si intentional felonies but ni sulod man si culpable felonies. Therefore, si katong example lang ang gihatag, dili siya exempted from criminal liability. Therefore, he is liable for reckless imprudence resulting in homicide. Okay, I hope you understand about this exempting circumstance. Let us proceed to paragraph 4 of Article 12. So, paragraph 4 of Article 12, any person who acts under the compulsion of irresistible force. And paragraph 6 is any person who acts under the impulse of uncontrollable fear of unequal or greater injury. So, I read both paragraph 5 and paragraph 6 in order for you to understand easily about these two paragraphs. Because, kung ato na siyang lunaon, makaingunta ay they have the same impact, they have the same outcome nga nihimo ang usa ka tawo kay tungod na hadlok. But there is distinction between the two. So, let us have an example. So, who acts under the compulsion of an irresistible force? Elements. The compulsion is by means of physical force. Remember physical force, that the physical force must be irresistible, that the physical force must come from a third person. So let us just let's just have an example. Here is it is a case decided by the honorable court. So see for example, here is Bakule. Bakule is nang harvest siya sa plantation. Now, nainabot nga mga group of armed malefactors. Group of armed malefactors or a band nga ningso dito sa plantation. Now, within that plantation is naay gitawag nga tapad nga eskwelahan. Now, ang tuyo sa mga group of armed malefactors is to kill those teachers nga naa dito. Now, pag-abot dito sa mga grupo, sa mga bandidong grupo, gipamatay. Gipamatay ang mga maestra. Now, nakita nila si Bakule. Nakita nila. Then, one of the culprits instructed. Kaya nakita naman nila. Giinan nila Bakule. Wala na diri. Giinan. Ilubong ng mga patayng lawas. Kaya kung dili na mo ilubong, ako ning idugsak nimo ang bat sa rifle. Then, padung na idugsak. So, there is an attempt. Or padung na gid siya nga dugsakon, sige dugsak. Or else, naigaw na siya. Naigaw na siya. Kay mura siya og resisting on his part si Bakule nga dili mo sunod sa ilang gihimo o gisugo. Pero tungod sa kahadlok, it's because of the physical force. Remember, it's because of the physical force and the irresistible. Meaning, when you talk of physical and irresistible, the force must be real, imminent, and naa siya existing. Dili kay hadlok-hadlok nga walay hinungdan. Muna giingon nga physical force. There is a physical force. There is the so-called violence. Okay? Now, tungod sa kahadlok niya, iyang gilubong. Lubong. Nawala na. Now, with that act nga gihimo ni Bakule, pwede siyang mahimo og accessory in the commission of the crime. Why? Because his act nga nag-conceal niya, iyang gi-conceal gihimo ni Bakule is to conceal the body of the crime, which is the body of those teachers that have been killed by the bandits. Dilubong mo niya. So meaning there was concealment sa body of the crimes. So masulod siya na to as accessory of the crime. Now, ang pangutana, ma-held liable ba siya as an accessory of the crime? The answer is no. Why? Because under the compulsion of an irresistible force, nihimo si Bakule sa paglubong atong mga patayng lawas kay tungod sa iyang kahadlok. It's because of the physical force coming from the bandits, coming from the group of the armed malefactors. So muna siya gitawag na to under the compulsion of irresistible force, meaning the force must be extraneous. Okay? And in fact, under this extraneous or reasonable force nga akong gipasabot, of course, there is an absence of your intelligence, of your will to commit a crime, and such will or such intelligence nga imong nahimo or imong act is against na sad. It is against your will. Nga naman, di ba gusto mong patay pero imuhang lubong. But imuhang gilubong ang katong pananglawas nga gipatay sa mga culprit kay tungod sa kahadlok nga ilang gipahamtang nimo on the irresistible force. On the irresistible force. Okay? Nga ni resulta sa imuhang kahadlok. Maabot sa uncontrollable fear karon but they have different way of compelling a person to commit a crime. Now, asa ang effect aning kahadlok nga gihimo ni bandits to commit a crime? Of course, directly to Bakule. Directly to Bakule nga kung dili niya ilubong isdugsakon siya sa rifle. And the effects is on the lesser degree than to the crime he committed. Okay? Muna gitawag na to nga irresistible force. Irresistible force. Always bear in mind when you talk of irresistible force, meaning it is extraneous. Extraneous. Extraneous siya. Now, let us proceed to paragraph 6. Any person under the impulse of uncontrollable fear of an equal or greater injury. So, impulse of equal or greater injury. Elements of this exempting circumstances. That the arrest which causes the fear is of an equal or of an evil greater than or at least equal to that which he is required to commit. That it promises an evil of such gravity and immunity that the ordinary man would have succumbed to. US versus Ilicanal. Now, on the case involving of uncontrollable fear, ang gihimo diha is there is a threat or intimidation. Not reasonable for, not the so-called irresistible force, but a threat or intimidation in order for a person to commit a crime. Remember the difference between the two? Mingon gani kog paragraph 5, ang nakapahimo nga ni commit ang tao og krimen, it's because of the extraneous force directly to the person who committed the crime. While when we talk of paragraph 6, it is the threat or intimidation in order for a person to commit a crime. And such threat or intimidation, or the effect of such threat or intimidation, is not directed to the person committed a crime. Or shall we say, dili siya mo'y mapatay, dili siya mo'y mingon nga patyon, but on the third person. Si for example, giingnan siya sa bandit nga, hala sige, ayaw buhata nga akong gisugo, kay patyon ako tanan nimong pamilya. Patyon ako imong anak, patyon ako imong asawa. So, with that threat or intimidation, that causes an impulse to an uncontrollable fear. Meaning, nahadlok ka. Nahadlok ka nga patyon ang imong pamilya kung dili niya nimo buhaton ang ilahang gisugo. Now, let's go to the effect. The effect is, the fear is of an evil greater than or at least equal to that which is required to commit. See, for example, patyon ang imuhang asawa, of course. Or, magpapatay sad sila og lain nga tao. So, there is an equal. Mingon sa siya nga, hoto na ko patay yung pamilya. So, greater injury ang mahatag nimo. That is why, muna gitawag na ito nga impulse of an uncontrollable fear. And the effect is directly to a third person. Sa pikas, ang effect is directly to the person who committed the crime. And the means that being used when we talk of paragraph 5 is reasonable force, a physical force for you to commit a crime. Diri sa pikas is the threat or intimidation for you to commit a crime. I hope you understand between difference between paragraph 5 and paragraph 6. But as a whole, the basis of that exempting circumstances is the word nga gibutang dito under sa discussion nato sa felony nga ingon nga an act done by me against my will is not my act. Therefore, he is exempted from criminal liability. Remember this word. An act done by me against my will is not my act. Going back to irresistible force, iyaha ba tong kagustuhan nga ilubong niya ang mga maestra nga namatay? The answer is no. That is against his will. Nga nang iyang gihimo kay tungod sa physical force, because of the extraneous force nga dugsak-dugsakon siya sa gitawag nga sabat sa rifle. Now, in the second scenario nga gihatag, arita sa uncontrollable fear, ihabang kagustuhan nga mupatay og laing tao? No. Mupatay siya kay tungod sa kahadlong nga patyon ng iyang pamilya. Now, within this paragraph 5 and paragraph 6, you are just considered as like as a tool. Nga sama sa kutsilyo nga gigamit siya pagdugsak or pagdunggab, pareha sa armas nga gikablit nga para mubuto, pareha sa yawi nga iabli sa pultahan para mangawat. Mura na siya ang mura og application nga akong mahatag nga makaingon ko nga susama. Kaya ang kutsilyo kung pasagdaan na di man na siya manunggab. Di ba? Ang armas di man na mabuto kung dili mo kabliton. So pareha sa sana, ikaw nga tao nga gisugo para mo patay, mura ka og armas nga gigamit sa pagpabuto. Ikaw tao nga gisugo diha nga mubuhat sa dili nimo kagustuhan, pareha ka sa kakutsilyo nga gigamit sa pagdunggab sa katao. That is why you are exempted from criminal liability. Sabtan. Now let us proceed to the last paragraph under Article 12. That is paragraph 7. Any person who fails to perform an act required by law when prevented by some lawful or insuperable cause. Requisites or elements under this paragraph: first, that the act is required by law to be done. Second, that the person fails to perform such act, that his failure to perform was due to some lawful or insuperable cause. Now, let us have an example that an act is required by law to be done. So, for example, naay pare. There is a priest. Now, ning konpisal, there is a confessor, ning konpisal siya sa pare, base sa ilahang nga plano to commit treason against the Philippines. And in your book 2 of the revised penal code, there is a prohibition for those person nga nakahibaw sa knowledge to commit treason, unya wala nimo giistorya to the government authorities or any lawful authorities, ma-held liable ka for misprision of treason. Remember, nasad sa definition sa felony niyo ko nga it is an act or omission punishable by law. When we talk of act, it is any bodily movement that will result into an external act for you to commit a crime. Kung mingon ko og omission, it is failure to do what is being required by law, or it is a positive act that you are required to do so. Diba? Now, ganun ako siyang i-mention, because a misprision of treason, mabilong siya sa gitawag na ito nga omission. Nga naman, that is your duties and responsibilities. You are required by the law to report to the government or any lawful authorities for any knowledge involving commission of a crime of treason. Now, kung dili ka mo ingon, dili ka mo istorya ana about imong knowledge, ma-held liable ka for misprision of treason. And ang imong basis is on omission. Failure to do what is being required by law. Now, going back to the topic about under paragraph 7 of Article 12. First paragraph nga giingon nga that an act is required by law to be done. Based on the elements niya, that the act is required by law to be done. Now, going back sa akong example, na si pare, na ay ni kumpisal si A, nga, father, na mangumpisal ko, kay part ko sa planning, nga, or nami gustong himuon, which is to commit treason against the Philippine government, or against the Republic of the Philippines. Now, question, required ba or kinahanglan ba nga mo sulti si pare ngadto sa government authorities nga oy pulis ni kumpisal nako si A nga commit daw silang treason against the Republic of the Philippines. Yun nakabutang anang misprision of treason nga any person or any Filipino citizen or non-resident alien who acquired knowledge or knowledgeable about the commission of the crime should report to the authorities. So, mao ba nay gustong buhaton or mahitabo? Supposedly, that is the rule. And that is provided under the provisions of the law. However, under this paragraph 7, pwede nga dili mo istorya si father ngadto or si priest ngadto sa lawful authorities. Diba? That the act is required by law to be done. Required by law? Yes, it is required by law to be done. And that the person fails to perform such act, that such failure to perform was due to some lawful. So, atong sudlon ron si lawful. So, ngano naingon man siya nga due to some lawful. Naingon siya nga due to some lawful act, it's because the confession of the confessor to the priest is covered by the privileged communication. Meaning to say, kay covered man siya sa privileged communication, there is a sacred rule of confidentiality. Remember that. There is a sacred rule of confidentiality. Meaning to say, kinahanglan siya confidential in nature. And in fact, kung imo siyang gamiton nga ebidensya against ni confessor is dili siya pwede nimo magamiton as evidence, it's because it is covered on the privileged communication between the priest and the confessor. Understand? I hope you understand. That is why dili siya ma-held liable. Exempted siya from criminal liability. Exempted siya from criminal liability. It's because of the privileged communication na himong lawful and of course, because of the sacredness or the sacred rule of confidentiality. Now, let us proceed to the so-called insuperable cause. Insuperable cause. Remember how we are talking about exempting circumstances. We are not talking about liabilities, but we are talking about exempting circumstances for a person to be exempted from criminal liability. And of course, under this paragraph 7, the same true with paragraph 4, that any person who acted under this paragraph are exempted from criminal and civil liability. Why? Because their acts are not considered felonious. Kung yung tag non-felonious, of course, there was an absence of an intent and fault in the commission of an offense. Okay. Now, inseparable cause. Say for example, municipal mayor arrested or apprehended a person who committed a crime in his presence. Now, nagpuyo siya sa isla. Nagpuyo. And then, walay presohan dito sa isla, kinahanglan pa mulabang ngadto sa mainland para mo file sa kaso o para i-detain si culprit or si akusado or si suspect. Now, 3 days ang biyahe sa bangka padong sa paglabang sa mainland. And under our law, most specifically on Republic Act 7438 or the rights of the accused under custodial investigation, there is a corresponding duration in order for you to file a case against the person nga imuhang gidakop. When it is a slight felony, the case must be filed within 12 hours from the time the person is under your custody. Kanos ang makamaingon nga under your custody? Of course, from the time nga imong giaresto. From the time nga imong giaresto, so na kay custody ana niya. So magsugod na tag-ihap o gitawag nato nga prescriptive period which is 12 hours. 12 hours para sa mga slight penalties. Now, kung mayroon tawag least grave, I know you can already determine the gravity of felonies since I already discussed under Article 9 of the RPC. Di ba? Now, mayroon tag least grave felonies. Itong mga correctional in character. Then, atong i-apply ana ang prescriptive period is 18 hours. 12 slight, least grave, 18. Mayroon tag 18 hours. Again, asa ito mag-ihap? From the time that person is under your custody. Kanos aka makaingon nga under your custody? Say for example, imuhang na-apprehend, imuhang na-aresto, sugod na kagihap. However, remember this, that counting of prescriptive period does not include Monday, Saturday, and legal holidays. Nga naman, why opisina korte ana? Di na mo apil og ihap. Even though it was not stated under that provision, but based on the jurisprudence, mauna siya gisunod. Kay walay tao ng court ana. Alas 12 sa kadlawon, imo di mo file kay kaso kinsa may mo entertain nimo. Di ba? By reason na lang o public policy og bang hunahuna nimo nga sakto, so why abli ana? That is why dili na siya maapil sa counting. Okay, I hope you understand. Including Sabado, sa may tao sa opisina, Domingo, way appeal, legal holidays, wala siya appeal sa counting sa kanang itong gitawag nga prescriptive period para sa pag-file sa kaso. Ngayon ni salutani because we are talking about insuperable cause and I need to discuss about this in order for you to determine nga lang niingon ko nga nahimo siya nga exempted. Now, let us proceed to the 36 hours. Unsa man ang 36 hours? Katong gitawag nato nga grave felonies. Grave felonies, ako na sa nang gidiscuss under Article 9. Under Article 9 of the revised penal code. Now, 36 hours, grave felonies. Going back to my example. Now, si municipal mayor nakadakop, kinahanglan pang idagan niya og 3 ka adlaw. 3 ka adlaw usa maka-file sa kaso. Now, si for example, slight lang, 12 hours. 12 hours. So meaning, lapas na kay 3 days man ang biyahe. Therefore, pwede untang mo file og kaso si dinakpan og arbitrary detention or unlawful detention as the case may be ngadto sa nadakop niya. Nga naman, kay kinahanglan man imong filean ang kanang imong ginakpan, otherwise maigo ka sa arbitrary detention kung police officer ka. And you detain a person, for example, you detain a person without legal grounds. And in fact, under Article 125 of the RPC, there are 3 different kinds of arbitrary detention. But we will not discuss on that matter. So, going back to the insuperable cause. Now, insuperable cause, tungod kay na insuperable cause, wala nimo na pa filean og kaso. Unsa may insuperable cause ato? Katong nagbiyahe, mo biyahe pa kag 3 ka adlaw. Usa ka maabot sa mainland. Naabdi kay mahimo nga imuha ng usbon. Mao man na siya tinod ba na siya realidad nga dili nimo mapailan within that period nga gi-require sa balaod kay kinahanglan ka mo biyahe. Mag-eroplano ka kung may eroplano des isla. Di ba? Kinahanglan ka magsakay og bangka or unsay any available transportation diha or means nga para maabot ka sa mainland. And ang pinakadali is 3 days para maabot ka dito. Therefore, you are exempted from criminal liability. Why? You are exempted. It is because ang imong gihimo is nasa insuperable cause. Ha? Lawful ang imong rason nga nung wala ka na napailan og kaso within the prescribed period provided under Republic Act 7438. Nasabtan? So I hope you understand. I hope you understand those circumstances that will affect criminal liability. And it is very easy for us now to determine between justifying circumstances and exempting circumstances. Para dili maglibog between justifying and exempting circumstances, tan-aw ra nimo ang mga requisites in the commission of the crime. Why? Kay wa may nagkaparehas ana. Ha, naglain-lain na. Si for example, justifying self-defense. Ari sa kadiri sa pikas, imbecility o insanity. Sa exempting. Basta timangan lang nimo ang effect. Muyong gani kag exempting, criminal liability exempted, civil liability dili exempted. Kung muyong gani justifying, civil exempted, criminal exempted. But on paragraph 4 of both article, diri sa pikas murag nagbakli ba? Ha, murag nagbakli. Diri sa pikas, paragraph 4 on the state of necessity, exempted from criminal liability but na siya ay tulubagon civil liability. Ari sa pikas, accident, performing a lawful act with due care, causes an injury to another without, the word is without causing damage or injury to another, without intention or fault. Wala ka na. So of course, ari sad ka mo ingon nga naa kay gitawag nato wala kay you are exempted from civil and criminal liability. So nakuha. Ingaya ra ang pagdeterminar between exempted and criminal liability. Just try to look or to scan over those paragraphs that have been mentioned under Article 11 and Article 12. And don't forget the general and specific exempting circumstances. So, also, I already discussed about absolutory causes on cases of, katong ipang-mention ako ganiha, nga about kini ang Article 247 on the slight and least serious physical injuries or injuries, part of the exceptional circumstances on cases of our relatives nga gi-conceal niya ang body of the crimes as part of the accessory of the crimes. They are specific or absolutory and considered as a specific exempting circumstances. And also, Article 332 of the RPC, susulod gihapon siya sa specific circumstances. And in fact, I already discussed about the difference between entrapment and instigation, which ang instigation is nasulod na nato siya sa gitawag natong absolutory causes. Unsa ganito ang absolutory causes? Ang absolutory causes, it is an act that is considered a crime. However, it is not punishable by law. Why? It's because of by reason of public policy and sentiments. Understand? So, daghan tang mga klase-klase nga masulod nato sa specific exempting circumstances, but kinahanglan sa nato nga naay provisions of the law. Otherwise, di ka pwede magpasagad-pasagad. And remember, kung ingon ganitag general exempting circumstances, kinahanglan nimo isod si muna na ay general man ini. So kay general man adto ko mo base sa paragraph 1 to 7 of Article 12. Now, on the next video, please be updated because I will discuss about mitigating circumstances, aggravating circumstances, and alternative circumstances para mahuman na to ang gitawag nato nga GMA or the factors or circumstances that will affect criminal liability. I hope you understand and you can distinguish now between justifying and exempting. If you have any questions regarding my discussions, or if you want more examples or any clarifications and suggestions, you can comment below. Or if you have something nga inyong ganahan nga ipadiscuss, just comment and I'll try my best to discuss those topics as best as I can. Thank you for watching, and once again, good day and God bless us all.